every morning that are decided the night before, every night for cases that are decided during the day, both in state and federal courts. And we have a team of lawyers that are looking at these rulings and categorizing them and analyzing them, trying to figure out what they mean. And it is a big job, and there's a lot there. This year, something did not happen that happened the year before. There were two federal judges, believe it or not, who issued decisions on Christmas Day in 2018. We didn't review those till December 26th, but this year we had no holiday rulings. But in the book that's on the tables, a good 10% of the rulings are from the month of December, and a good percentage of those are from the last week of the year when courts are cleaning up their dockets and issuing their rulings. But our method is to try to break down all these rulings, discern trends, identify issues that can help clients comply. It's better not to be a defendant in the case and to spend $1 on compliance than $10 or maybe $100 to defend yourself. I teach at Northwestern. I've been there quite a while, and the law students there read their law books and learn about the case or the company. And no company wants to be known as the case or have its name attached to the case. Far better not to be a defendant in one of these cases. But what we did is we distilled those 1,455 rulings from 2019 and tried to break them down and say, what does this mean? What does it mean today? And what does it mean in terms of what's occurred in the last decade? So I chose 5 trends, 5 themes that I think are very, very telling for corporate America, for what to keep your eye on, what's evolving, what's happening, and what probably is going to be the future of both compliance and litigation trends. And so I'd like to, in the next few minutes, kind of take a tour of those 5 trends and break them down statistically and show you what occurred throughout the United States, both in federal courts and state courts last year, to try and give you some insights as you leave today on what can I do at my company to stay ahead of these problems, get out ahead of them, diffuse them, and make sure I have a better workplace and that I'm not a party to one of these cases. So the very first trend involves certification of class actions in federal and state court, and we broke these down by circuit. We looked at all of them. There were 303 last year in federal courts, and by and large what it showed is plaintiffs, workers, do better than defendants or employers, and more cases get certified than those that don't. There are certain areas of law where employers do well. Employment discrimination is an example, but there are other areas where workers or their advocates do better, and wage and hour is one of those areas. And as the statistics bear out, there are certain what I would call hotspots or magnet jurisdictions where employers get sued more often than in other areas of the country. And those traditionally have been and continued to be in 2019 on the left and right coasts in what's known as the Second Circuit, which is centered in New York City, and the Ninth Circuit, which is centered in California. The court sits in San Francisco. And by hook or crook, the manner in which judges in those jurisdictions approach issues in these sorts of cases tend to favor plaintiffs, tend to allow advocates for workers to certify their cases and to achieve better results than in other areas of the country. So not unlike selling your home, location is everything. And if you're in the Second or Ninth Circuit, workers seem to have an advantage as compared to employers. But there's more to that in the trends. And so one of the things that was also important is, if you're an employer, what are you apt to be sued over? I would have answered that question in 2010 by saying avoiding discrimination. I would answer the question today in 2020 by saying it's how you pay people. The number one area where lawsuits are brought is in compensation and pay decisions. From 1998 to 2015, wage and hour cases increased every year in federal courts. It was like a wave that never crested. And in 2016, for the first time in 16 years, there were less cases filed. And in 2019, we now experience the fourth year in a row with a decrease in filings. Nonetheless, still a lot of cases, and nonetheless, over 90% of the certification decisions involve wage and hour areas. But more definitely, we're on the downward trend of a bell jar curve where there are less lawsuits. Now, what would you attribute that to? My personal belief that it is somewhat a symptom or a manifestation of the Supreme Court and its decisions, particularly in 2018 in the Epic Systems decision, which greenlighted the use of workplace class action agreements that have what are known as class action waivers. It is a contract or a form of a contract, could be a two-page piece of paper, more likely than not, entered into at the time that an employee onboards at a company that basically says if you have a grievance, you cannot bring a lawsuit, rather you bring it in arbitration, you bring it on behalf of yourself, not on behalf of a class, the so-called class action waiver. What I see and what I see clients experiencing is instead of being on the receiving end of a lawsuit these days, they'll get a demand letter from an attorney, or an attorney will file an arbitration claim on behalf of one employee. I think that is probably the number one reason why you see the declining number of FLSA lawsuits that are filed. 99% of those lawsuits are filed as class or collective actions on behalf of multiple people. The arbitrations are brought on behalf of typically just one person. So as we open the new decade, what can employers expect to see in 2020? Well, we don't know. One adverse data point would be a raising of the minimum wage in over 20 states. What does that mean? It means the amount of damages that one can recover will be greater in 2020 than in 2019 because the measure of damages will increase. What we have seen with a decrease in federal court filings is an increase in filings in state court in states such as California, Massachusetts, Pennsylvania, New Jersey, Michigan, and Florida. Why those states? Well, those states have longer statute of limitations, more generous damages remedies, and plaintiffs' lawyers know they can recover more in state court than they can in federal court under those state laws. So the Supreme Court take it away in one area, and plaintiffs' attorneys nothing if not inventive in terms of figuring a workaround. So kind of net, I think the same amount of litigation may be filed. The numbers might, again, be a little lower in federal court, but because of the rise of the minimum wages, the issue over the joint employer rules that Aaron talked about, more entities being sued over a wage violation than before, not one employer, but maybe multiple employers, and the Trump DOL. As we'll talk about with government enforcement litigation, the federal government is in the business of filing less lawsuits today than before, and where it files less lawsuits, the plaintiff's bar tends to fill that void. So the jury's out as to what will occur in 2020. Certainly, I think that lawsuits will continue to attack the way in which employees are paid or independent contractors are paid. The issue will be, where are they going to be filed, in arbitration, in state court, or federal court? My prediction would be less in federal court, more in state court, and certainly more in arbitration. Another trend to take away is what I call an indication of what I would describe as the stock market theory of litigation. I cross swords with very talented plaintiffs' lawyers that come from different walks and areas of life and law, many of whom used to file securities fraud, director and officer litigation, and have now kind of migrated to the wage and hour space. Why? success begets copycats. We'll talk about some of the larger settlements and the ability to convert lawsuits into certified cases, which is the holy grail in this sort of litigation. Once a case is certified, it tends to settle because of the hydraulic pressure imposed on an employer dealing with a large piece of litigation. And so in essence, you have many, many skilled lawyers on the plaintiff side rushing into this space. The barriers of entry are very low. All they need is one client in a wage and hour case paid on a common payroll system. They don't need a plaintiff's expert, like in an employment discrimination case. A statistician might cost them $250,000 to come up with a report, or a labor economist in an ERISA case. And within 1 month to 3 months, they could certify their wage and hour case with a very low minimal investment of time, yet a high return. Hence why the way in which you pay people still is where the rubber meets the road, where the most plaintiffs' lawyers are attracted to suing companies. But for the first time in 2019, we saw a different trend than we saw in the past 9 years. And that was, besides the Second and Ninth Circuit that I talked about before being the magnet jurisdiction, now the Fifth down in the Texas area and the Sixth in Ohio were equally populated with cases as compared to the Second and Ninth. In essence, both coasts moved to Middle America in terms of the volume of filings and the settlements, so that was a geographic shift that we hadn't seen before. My personal take is you have more lawyers in cities like Cincinnati, Cleveland, Nashville, Houston, and Dallas filing wage and hour class actions than ever before. And they used to be filed in New York City and San Francisco. So you're seeing the development of the case law in those circuits at an increased or enhanced basis that we didn't see before. So again, like real estate, location is everything. And statistically, what was borne out in 2019 was Middle America was an area where plaintiffs' lawyers were filing lawsuits and certifying cases like never before during the period of the decade. So the next slide to me is the most striking, 81%. A little more than 8 out of 10 motions that plaintiffs' lawyers brought to certify their cases in the wage and hour area were granted. That is the single highest figure in the last 10 years. It had never been over 80%. You can see the slide on the right, and they were in the mid or high 70s, but this was the first time it ever went over 81%. So these cases can be won. These cases can be defeated. Depends on the case, depends on the judge, depends on the jurisdiction. But by and large, that's another factor that's attracting many of these plaintiffs' lawyers into the area where they know that statistically they stand a very, very good chance of certifying their case. So what happens next? And you see that figure of 58% and 42%. That's what's called a decertification process. After the judge would certify a case, the judge would say, now I want the parties to undertake discovery, come back to me in a year, 18 months, show me all the evidence that's been accumulated, and I'll decide if whether based on all that evidence, the case can still truly go forward as a collective action or class action. And there, employers are winning 6 out of 10 times. Employers are doing very well. The rub or the problem is the cost. The cost of getting from the first certification ruling to the second certification ruling is immense. What's the cost? Looking at all your servers, pulling down all your email, pulling down all your documents, all your payroll people, your HR people, having to go through depositions on a nationwide basis in some of these cases. So a lot of cases settle between 81% and 58% because employers say it's just too costly, too difficult. I'd rather spend my money to get rid of this case than to litigate it. But those litigating it, because of the compliance procedures ongoing at these companies, stand a pretty good chance 6 out of 10 times to decertify that case, and it's basically vaporized. It goes away. And all those people who opted into the case are basically kicked out of the courthouse, and there's only one person left. So The 58% pattern was a little higher. It's not as high as it was a couple of years ago. It's 63, but it's showing that employers doing a good job with compliance, and if they play out the string, can do very well. The last slide talked about the other spaces we looked at, which is ERISA over pension plans, retirement plans, or employment discrimination, gender, race, national origin discrimination. For every 10 wage and hour cases filed, there's probably one ERISA case filed or one employment discrimination case filed. And what a difference a couple of years make. If we had this presentation in the year 2012, the year after the seminal ruling known as Walmart Stores versus Dukes, where the Supreme Court ratcheted up the standards to certify a case under Rule 23, that percentage under both ERISA and employment discrimination was in the 20s. I've seen it as low as like 19. Well, what's occurred since 2012? How come it's up at 64 and 65%? I would say this is what I would call 2.0 lawyering by the plaintiff's bar, reinventing their theories to adjust to these new standards erected by the Supreme Court. And so what we're seeing now is smaller size cases attacking one discrete employment practice, such as an application on an onboarding process where an employer asks for a criminal background check. And there'll be a Title VII lawsuit saying that that has an adverse impact on minorities, and there's no business justification for ascertaining whether or not somebody has a criminal background because that has no bearing on their performance in the workplace. Or a case against promotions in one plant that might involve 335 people rather than the Dukes case that involved 1.6 million females at Walmart seeking promotions and pay increases. So seeing a downsizing of the cases, smaller, tighter, designed to try and secure certification, and that has driven the percentage up. We're going to show you conversely in some slides what's it's done in what I call conversion in terms of the value of these cases. But by and large, in 2019, the plaintiff's bar did better in any year of the decade in terms of their 81, 65, and 64 percentage points in terms of certifying their cases.